All right. Good morning, everyone. Welcome to our latest session on the Women in VC series that we've been doing over the last sort of year. My name is Chandra Shih. I'm a partner here at Lowenstein Sandler. I work in the ECVC group alongside my colleague Alyssa Frederick, who's on the call, and Meredith Beuchaw, who is a partner in our New York office doing venture-backed M&A. The three of us have been doing a series of these sessions throughout the year to help women founders and funders get smart on all things necessary to sort of show up in the boardroom and otherwise, have the information we think you all need to go out there in the world and operate. And this session was planned a little bit last minute, in the sense that it's a time sensitive subject. We are covering today the Corporate Transparency Act, which is something that's going to take effect on January 1st of 2024. Our colleagues Rob Johnston, Paula Ladd, and Melissa Wiley are here, and they are going to help read you all in on what the Corporate Transparency Act is, why it will absolutely impact every single startup company that many folks in early stages work with, and why it may actually also impact venture funds, for those of you who sit at funds, both with respect to your portfolio companies, but also potentially with respect to your fund itself too. So I will hand this over to Melissa. She'll go ahead and introduce herself, and we'll go from there. Thanks all.
Thank you, Chandra. I am Melissa Wiley. I am a partner in our tax practice and our private client services practice here in Washington, D.C. My focus is primarily on tax controversy, representing clients in connection with audits, appeals, and litigation in the tax context. And along with that, I often get involved in questions about information submitted to our friends at FinCEN, which you'll hear us talking quite a bit about today. And that is how I ended up working on the Corporate Transparency Act. Rob, do you want to introduce yourself?
Sure. Hi, so I'm Rob Johnston. I sit in the New York office. I am in both the investment management practice group as well as the white collar criminal defense group. Along with Paula, we co-lead the firm's anti-money laundering practice that has 16 people in it. And my practice focuses on compliance, internal investigations, and government enforcement action. Paula? You're on mute, Paula.
I'm Paula Ladd. Thanks, Rob. As Rob mentioned, I help lead the AML practice in our New York office. I focus on both ad hoc advisory as well as compliance-related matters associated with our clients' needs with respect to AML. And I also do, my practice also focuses on transactional work in the derivative space.
Great. So with that, I think we will kick it off. You heard me mention FinCEN, our friends at the Financial Crimes Enforcement Network, which is an agency that sits within Treasury. They are the agency that has been tasked with administering the Corporate Transparency Act. When I speak to tax-oriented groups, I often say that if you think the IRS is underfunded, you should have a conversation with FinCEN. It is, by comparison, a very small agency. And when we get into exactly what this new law requires, you'll understand what a significant lift this is. I know that Rob, Paula, and I have been talking about the Corporate Transparency Act and sort of the sky is falling for well over a year now. That has picked up significantly over the past several months because while there have been several attempts to push off this new reporting requirement to FinCEN, we find ourselves now on December 18th with this thing going live on January 1st of the coming year. Now, just on a high level, by FinCEN's own estimates, this new requirement is going to require reporting to the government by 32.6 million existing companies. So 32.6 million companies that exist today, starting next year, are going to have to file a report with the government, identifying the beneficial owners of their entity. And we will get into what that definition means within the context of the CTA, as well as other definitions that apply. In addition to that, there will be 5 million new reporting companies added each year. And so it doesn't take a lot of advanced math to look at those numbers and say, wait a minute, what you're telling me is in the first year, 37 plus million entities are going to have to report to this thing. We saw what happened with healthcare.gov. Where those of us who have been talking about these requirements and what FinCEN has been doing to get ready, or perhaps the lack thereof, are all going to be watching with great interest the first couple of months to see how this gets off the ground. But the fact is that it's here, and with just 13 more days left in this year, it doesn't look like anything is going to stop it from becoming fully effective in January of 2024. Now, one note, when I talk about, and I know we talked about this in prep for this session, the Corporate Transparency Act, a lot of people sort of assume that this is for big businesses, right? When in fact, it is just the opposite. We'll talk about who a reporting company is and the various exemptions to that definition. And really, when you look at the exemptions, what you realize is that the big guys are the ones who are carved out. So who does that leave us with? It leaves us with all manner of entities that are privately held. It leaves us significantly with the smallest entities out there, entities that may have a handful of employees, entities that may just be holding companies, and probably a lot of the entities that you are dealing with yourselves. My clientele focuses often significantly in the private client space, where we are dealing with wealthy individuals with family offices. Those folks are going to have a huge lift because, very broadly speaking, the entities that have to report under this new rule, it's triggered simply by how the entity came into being. And what I mean by that is that a reporting company under the Corporate Transparency Act, a company that is going to have to start reporting to FinCEN next year, is any entity that was formed by the filing of paperwork with the Secretary of State or similar in a U.S. state or tribal land. So that's going to be our domestic reporting companies. On the foreign side, foreign companies will be swept into this regime if they are formed in a foreign country, but then they register to do business in a U.S. state or tribal land. And it is the act of that registration, the act of that formation, that subjects an entity, opts them into this whole regime, whether they want to be there or not. Like I said, there are 23 different types of exemptions. We're going to go over some of those in a minute in greater detail. But I want to emphasize that those exemptions are really pulling out what you think of as the bigger companies. And the reason for it is this. The Corporate Transparency Act came about as a response to significant criticism throughout the world by the global community that the United States was not doing enough to combat money laundering, tax evasion, other financial crimes that were being done through entities that sort of had very opaque ownership. So you can think about entities formed in sort of the secrecy jurisdictions. We all know that there are a handful of states where it's pretty easy and you don't have to give a lot of information when you're forming an entity. The criticism was aimed at, hey, I can't tell who owns that Nevada LLC because when I go in and I look at your records, Nevada or United States, all I see is another LLC. And on top of that, all I see is a corporation. And the corporation is owned by more LLCs and limited partnerships. And I can't figure out who is actually owning the assets and controlling the entities. So when you think about the exemptions hit at entities where the government feels like it already has enough information. It looks at companies like publicly traded entities. It looks at companies like banks, insurance companies, utilities, anything that has to register with another aspect of the government, where the government feels like it can get the information it would need if it needed to figure out who the beneficial owners of the entity were. These are all the folks that are going to get swept out of this law. Again, who does that leave? It leaves all the LLCs with a handful of employees, or that might be holding companies for, a certain investment or a certain piece of real estate. So again, on this slide here, you'll see that definition of domestic reporting company that we just talked about, the definition of what a foreign reporting company it is, and a list of all the various exemptions that we have that really hit at the larger companies that are already reporting extensively. On that list, I'd point out are also tax-exempt entities, entities assisting tax-exempt entities, which are going to be your supporting orgs, broker-dealers, money services businesses. So think about entities that are already reporting a lot of information to FinCEN, a lot of information to the Treasury Department, the SEC. These are the folks that are going to be carved out. Rob, why don't we move to the next slide?
All right, can I just jump in for a
One
sec? I think
Yeah.
this is a really important point. I just wanted to underscore that. So for everyone listening, what does this mean for you? If you are the founder of a startup that's going to seek venture funding, a C corporation, you create your C corporation online or with your lawyers, immediately you will be subject to this and you're going to have to file. If you are an angel investor and you create an LLC, a personal LLC to use to make angel investments, maybe you haven't even made investments yet, but you've just created that entity, you will be required to comply with this. And I'll let Melissa and Rob and Paula talk more about what this means for venture funds and more complex entities and interrelated entities. But everyone who forms an entity who doesn't have an exemption will have to comply with this and make a filing.
And Alyssa, you remind me of something that I only embarrassingly twigged onto about 6 months ago, which is that my husband has an LLC that he uses to make investments. And after a year of talking about this, it just occurred to me that he's going to have to make a filing. He asked me if I would do it for him. I said, we'll have to see, what the holiday gifts are this year. There might be some arrangements we can make. But it really underscored to me that, oh my gosh, I'm somebody who's out here talking about this all the time. And it didn't even occur to me that I would have to be making one of these filings within my own home. Mentioned that there are 23 exemptions, and I want to make a couple of quick points here. As you'll see, we've called out on the slides here some of the exemptions that we thought would be most useful for this community. For any of these exemptions, as you can see, the definitions are very detailed, and it is really important to go into the regulations. I know that's not what everybody wants to do over their holiday break, but to go into the regulations and really figure out what they're getting at and whether or not you qualify. So a lot of these are going to be by specific reference to other laws, right? You can see exemption 1, securities reporting issuers. It's going to be issuers of securities that are registered under Section 12 of the 34 Act. Broker dealers, those are going to be as defined in Section 3 of the 34 Act. Investment companies and registered investment advisors. Again, we're defining these companies by reference to other laws here, the Investment Company Act of 1940. There is a very specific exemption, exemption 11, for venture capital fund advisors that we thought that would be really important for this particular group. And you can see here that, again, we're looking to the Investment Advisors Act of 1940. There's a requirement that the Form ADV filing with the SEC. You will get an exemption if you satisfy that specific definition within the regulations. If we could go to the next slide, Rob. And the last thing that I want to talk about, there again, a couple more here: Commodities Exchange Act registrants, pooled investment vehicles. There again, there's a very detailed definition of what that means. This large operating company exemption right here in number 21, a lot of companies that I talk to think that this will be sort of their slam dunk, and I remind them again that they need to take a look at the definitions here. The large operating companies only cover entities that have 20 or more full-time equivalent employees. They have to have reported at least $5 million of gross sales or gross receipts on their prior year IRS return So they have to have filed. If you're brand new, you're not going to get into this because you have to have that return. And you have to have a physical operating presence within the US. And what does not count as a physical operating presence is a space that you share with an unaffiliated entity. So if you have shared space with other smaller entities that are not within your corporate structure, you're going to get busted out of this exemption. Again, very, very important to look at the definitions.
And
And
also,
then
I would just
yeah.
add in, Alyssa, the 20 employee requirement, you cannot aggregate employees across affiliates.
Bingo.
So, depending on your structure, there might be an upper tier holdco with no employees, and then the employees might sit a level or two down in the structure. That
Mhm.
upper tier holdco will not have the large operating company because the employees don't sit at that entity at that level. So it's
Exactly.
very, that's another area I see some companies getting tripped up because they think that they can, for tax or other liability reasons, they might have employees sitting in one corporate entity, and then the commercial activities in a separate entity. Unfortunately, that won't work for the large operating exemption. There might be good
Great.
reasons to keep it that way for HR and employment law reasons, but for the CTA, you can't commingle or aggregate across corporate entities.
So the other piece of that too, that you mentioned for tax purposes, I get the question a lot of, well, what if I have a disregarded entity, right? It's a single member LLC. It doesn't file its own tax return. Surely I don't have to file for that. To which I say FinCEN doesn't care about that. FinCEN does not care if you're disregarded for tax purposes. You are not disregarded for CTA purposes unless you separately fall into one of these different exemptions. The last thing I'll mention on this slide before I think I'm turning it over to you, Rob, is that there is an exemption for subsidiaries of many of these exemptions. So if you're an entity and your ownership is an exempt entity, you may also be exempt, but you need again to work through this exemption 22 because not all of the exemptions are covered under this. You have to make sure that you are in one of them that is covered as a subsidiary. And to be honest, I've had a lot of clients who have said once they've mapped out all of their entities, like I'm just not dealing with whether it's exempt or not. The problem is that if you are claiming an exemption and for some reason you fall out of that exemption, you now have 30 days to get into the database. And their view is like, we have nothing to hide here. I'd rather get into this database, not have to worry about flip-flopping in or out or what I need to report. Because as we'll get to a little later in the presentation, there are significant penalties that can apply here for non-compliance. And those penalties apply to the people who give wrong information. They apply to the people who knowingly file that incorrect information. And they also go up the chain to the senior officers and the folks who are in charge of these entities. They also may bear liability for the penalties if incorrect filings are made. Rob, I'll hand it over to you, I think.
I think actually Paula.
I'm sorry, Paula.
Oh, no, that's okay. That's okay. Now, we've talked a little bit about, what is required, and what a reporting company is. So we want to get into next, what is actually required to file or who is your beneficial owner? And if you're a reporting company, your next step would be to look at that information. And a beneficial owner, for purposes of the CTA, would be any individual who directly or indirectly exercises substantial control over the reporting company or owns at least 25% of an ownership interest in the reporting company. There's no limit to the number of individuals who can be reported for exercising substantial control. What's interesting in the rule is that control itself is not specifically identified, but there is guidance to provide some map in terms of determining who you should be reporting in terms of individuals who would exercise substantial control and therefore be a beneficial owner. An individual who can exercise substantial control over a reporting company would generally fall into four areas. It would be an individual who is a senior officer of the company's president, their chief financial officer, general counsel, chief executive officers, officers of that function. An individual who has authority to appoint or remove certain officers, or a majority of directors or a similar type of body of the reporting company. Your third area would be individuals who have important decision-making responsibility for the company. And that would include decisions that have to do with the business, the finances, such as like sales and lease, mortgages of assets, or decisions regarding major expenditures or investments. And then the third area would be structure. So an individual who would be able to make decisions regarding reorganization or make amendments to important governance documents or policies and procedures. And then the fourth, as always with these rules, there is FinCEN provided us a lovely catch-all. And so basically, if you don't fit into any of those three previous areas, if you exercise any form of substantial control, you would be an individual who would have to report. We can go to the next slide.
And just, there's a question in the chat, and I'll just share it for the group. So this is important, and we'll talk about it in a minute. There's going to be a change management aspect to CTA compliance. And so if you are a reporting company that does not have an exemption, and your board of directors, the composition changes, you have to keep the information in the system current. So you'll have 30 days to make an updated filing. Or let's say, you know, Paula and Melissa have XYZ LLC and they own it 50-50. And then I come in 6 months later as an investor and we now own it a third. Again, that filing would have to be updated. So we'll talk about that a little bit more at the end for compliance. But since the question came up now, I just thought I would highlight there's an ongoing duty to keep your information current.
So in addition to the substantial control, the other area of beneficial ownership that falls under CTA would be any individual who owns 25% or more. And for purposes of ownership, any of the following areas would be included in your calculation to determine ownership. And it would include any kind of interest such as equity, stock, voting rights, capital or profit interests. Interestingly, convertible instruments, options, and other types of privileges to buy or sell any of the foregoing. So any other instrument, contract, or mechanism used to establish ownership would be included. And a reporting company may have multiple types of ownership interests. So you'd have to really look at all of the ways individuals may own in the reporting company. An individual might be a beneficial owner through substantial control, ownership interest, or both. And reporting companies are not required to report just one person. They are you can report multiple beneficial owners. A reporting company could have a beneficial owner who exercises substantial control and owns 25% or more interests. As far as I think the guidance has said right now, you don't have to identify how the person exercises the substantial control or how they own or why they're the beneficial owner. It's just reporting them as the beneficial owner. So the company could have beneficial owners who exercise substantial control and controls at least 25% of the company. There's no limitation on the number of people that you would have to report.
And Paula, you point out something really important here when you said, I think the guidance says, the reason we say that is because even though this requirement goes into effect on January 1st, we still don't have a final reporting form. We still don't have a form that would allow people to apply for identifiers that we'll talk about in a little bit. There's still not public access to the database itself, so that commercial entities can kind of play around in the database and provide filing services. Like we are so close to this going live, and yet so in the dark about so many things. So if you hear us kind of hedging a little around
Hedging, yeah.
it is not for lack of knowledge on our part. It is for lack of answers on FinCEN's part.
That's a great point, Melissa. Thank you. And in addition to the reporting, it's based on the guidance, based on the final rule and the proposed rule. FinCEN expects their expectation is that you would report at least one beneficial owner, and so you should do the calculations to figure out the ownership on that level. In addition, I think we can go to the next slide. Examples of the way an owner would exercise either direct or indirect control, because again, the control and the beneficial ownership could be direct or indirect. Examples of direct would be owning in joint interest with one or more persons of an undivided interest in ownership. Examples of indirect control could include over the reporting company would be owning or controlling one or more intermediary entities, perhaps separately or collectively own or control ownership interest of the reporting company through a contract, through another individual, like instances of a nominee or intermediary or custodian relationship or agent. The company, again, could have more than one type of ownership interest. And go to the next slide.
Company applicants?
Yes, so we'll talk about company applicants. So after identifying the types of beneficial ownership interest that your company has, you would then also be looking at the individuals who, would be considered the company applicants. And a company applicant would be up to 2 individuals who would qualify by either directly filing the documentation to create or register the company, or the individual who is primarily responsible for directing the controlling of the filing. The company applicant could be the corporate agent in some instances. The rule specifically takes into account trying to encompass and capture individuals like your attorneys or your accountants. And I guess I'm leading into the next slide, but the FinCEN wants to capture the individuals who are forming these entities. And so the intent behind the rule here, and this individual called the company applicant, is to, for instances like, let's say the Panama Papers, attorneys like Mossack Fonseca, or I had a colleague who made a good point, and I chuckled. They want to capture your Better Call Sauls, right? So they want to be able to identify and create connections for law enforcement of bad actors who are enabling anti-money laundering through the formation of shell companies and hiding behind those structures. Rob or Melissa, did you have anything else to add on this point? I didn't have anything else further.
Just to underscore the point, in one of the frequently asked questions that FinCEN has put out, FinCEN deliberately and expressly wants to capture the lawyers and accountants that are overseeing the formation of an entity. As I say to a lot of my colleagues, that's a feature, not a bug. And so if you are putting together filings for entities that you create after January, it very well may be the case that someone on your team, while not the person who physically handed paper over to a Secretary of State, nevertheless directed or oversaw the creation of the entity, told CT Corp to go do something, that person who told CT Corp to go do something is going to be captured.
Right. And
yeah.
I was just going to add to that. The one caveat with the company applicant is once they're filed, you would not be able to remove them. So let's say you change from CSC to CT Corp, or you have an individual, let's say I know from a law firm perspective, many of us have formed companies at our law firms, and either you're working with your paralegals or junior attorney. Once those people are identified, they will stay in the system as the original company applicant. And there's a purpose to that. So FinCEN definitely took a broad approach when it came to defining the company applicant, and it was contemplated that they wanted to capture the employees of businesses and who it's their business to form companies and their agents. So
what I like to say to people, and I think it's true, what FinCEN is asking you to report typically is not complicated. There's someone who owns more than 25%, someone who has substantial control of the company, the name of the person who clicked a button on the Delaware Secretary of State website. What is, I think, challenging is some of the deadlines and managing the deadlines. And so there is a tremendous opportunity for hyper-technical violations. I called them foot faults over the summer when watching the US Open talking about this. So for any entity created before the end of the year, so if you get it created in the next 13 days, or it's in existence as of December 31st, we will have a year until the end of 2024 to make any filings if filings are required. So a piece of practical advice is if you have a transaction coming up and call it the first quarter of 2024, when we all expect this website to crash or otherwise be unusable, it might be wise to form that entity now and sort of hardwire some additional time to do the filings for CTA. Now, if the entity is formed in 2024, we have 90 days to determine whether or not a filing is required and to make that filing. And then from 2025 and beyond, that 90 days actually shrinks to only 30 days. Updated reports, we touched upon it earlier. And this is partly why we work really hard to try to find exemptions for most of our clients. Because if you're exempt, you don't have to make a report. You don't have to update a report. You're good. If you are a reporting company that's making a BOSS filing, as we mentioned earlier, if there's any change to the information that was reported to FinCEN, then there's a 30-day window to file an updated report. There is a bit of a safe harbor with respect to corrected reports. So if you make a filing that you think in good faith is correct or accurate, and you come to learn it's actually not, you have a 90-day safe harbor to fix the filing. FinCEN is very much prioritizing getting the filings in, doing your best, don't miss the deadline. But if you do have an error or an inaccuracy that needs to be fixed, you have this 90-day safe harbor to do so.
And Rob, I'll just add for the folks sitting in this room, the updated reports feature, that's something that you're going to have to be thinking about each time you are doing a financing round. Each time you are actually doing a safe round or other convertible security, those types of instruments are specifically caught up here when you're thinking about ownership percentages, even though we don't normally think of them that way. And so it will be part of the analysis, whether you're on the investor side and you're putting money into the company, or you're on the founder operator side. It's just going to be something that has to be thought about, and that 30-day window is going to be tight, and as we understand it, strict. The other thing that we are anticipating at this point is that we will start to see reps and warranties around CTA compliance go into offering documents So we're expecting it to be stuff that's going to come through in your stock purchase agreements. There may be covenants and ongoing requirements to provide information as needed in order to comply with CTA. So we do expect this to filter through over the next, 3, 6, 9 months into the type of typical sort of venture deals that we see.
And the math can get a little bit complicated on the 25% ownership piece, because the CTA requires that we treat any warrants, options, etc., as if they had been fully executed or fully diluted. But then there's a provision at the end of a lengthy section of the rule on how to do all this math that effectively says, but if it's too complicated or too hypothetical, just go back to strict 25% ownership. So we are supposed to make a good faith effort to do the calculation as if all the warrants and options have been exercised. So what exactly needs to go on our report? So again, we don't know the format of the report because Vincent in his wisdom, despite having promised that the website would be available to the public in May or June, as we sit here today on December 18th, it is still not yet publicly available. But in any event, there's a number of data points from the rule that we know will need to be required. So for the company, the full legal name, any DBA or doing business as names, complete current address, jurisdiction of formation, and tax identification numbers. Now, for the individuals who get reported on the form, so this might be the company applicant, it could be the 25% beneficial owner, it could be the control person, like your chairman of the board or your general counsel. We'll need the full name of the individual, the person's date of birth, some sort of document to prove address, and then a government-issued photo ID, such as a driver's license or a passport. And that will, again, have to be kept current. So if the passport expires, an updated passport will have to be uploaded. If the person moves, then their information would need to be updated as well. And so again, back to my earlier point, there's a lot of opportunity to make hyper-technical mistakes. And for example, I don't know how many companies, are tracking in real time when one of their senior officers moves primary residences. But under the rule, if that person was listed on a BOS filing, his or her new address would need to be updated within 30 days. So the teeth of the rule, it comes at the very end of the rule and at near the end of our presentation. So there are potential criminal and civil penalties for non-compliance. So the company itself could be fined up to $500 per day of non-compliance. The person who causes the company to fail to comply could also face civil and criminal penalties, including up to 2 years in prison. And that part to me seems logical. So, if it was my job to report information on XYZ LLC and I willfully give incorrect information or willfully fail to do it, that to me makes sense that I would be in trouble. The real wrinkle here, which is, I think, pretty unusual, is let's assume that Paula is the managing member of XYZ LLC. By virtue of her position as the senior officer, she also could face civil and criminal penalties, even though it was my job to do the filing. So, to the extent that you need buy-in in your organizations to take this seriously, it's helpful because you could go to the people who would be in scope as senior officers and point out to them that it's not just potential fines for the company itself, but they could be in the crosshairs by virtue of their position. So who's going to have access to this database? So
this is my favorite slide.
You can take it away, Melissa. But since Melissa is our tax enforcement whiz, so what is IRS enforcement going to do with all of this information uploaded to FinCEN?
Yeah, so I will also disclose that prior to going to law school, I was an actuary. And so I think a lot about data and how it behaves and how the government is likely to use that data. And you heard both Rob and Paula talk about, you know, the information being requested being features, not bugs, that the government is looking for patterns here. This is a primary example of that. So there's a number of ways in which law enforcement can access the database. It's got its whole separate provision within the law and the regulations, but the IRS has its own special access provision for, quote, tax administration purposes, and that's defined as it's used in another section of the code, 6103B4. And it talks about the IRS being able to use this information for assessment of additional taxes. So think audit, collection of taxes. Money is already due and you say you don't have it. Well, let me just go check the BOSS database and see if that's really true, or if you actually own other assets that you weren't disclosing. Enforcement, litigation, publication, and statistical gathering. That one's not the interesting point. But for me, the part that I've been thinking about a lot is the IRS's audits of, in particular, they've been focusing quite a bit on partnerships, large partnerships in the hedge fund space, in the venture capital space, the real estate space, because they realize that their enforcement in those areas has been woefully inadequate. And I can only imagine that part of what they will be doing is, as soon as they pull up a taxpayer in this space, they're going to be searching this database to find out all of the, not just the individuals associated with that entity, but the other entities that are associated with that entity, because they know that they lack the ability to really see the bigger picture of all the different interconnected entities. And this database is going to, at least in its best form, allow the government to do that, not just for anti-money laundering efforts, but for tax evasion efforts. And I very specifically say in its best form, because one of my big concerns here is the whole notion of garbage in, garbage out. As my colleagues have explained, the definitions that apply here are, they're difficult to work through in a lot of situations where you have kind of non-traditional structures. And to the extent that companies are just saying, you know what, I'm just going to throw everything in there because I don't want these penalties, right? Like I don't want to get stuck with $500 a day or possible imprisonment because somebody at the government thinks that I was purposefully trying to hide something. I'm just going to throw it all in, and then they can't say anything to me, which, you know, in the face of definitions like this and a whole new reporting regime, I can't blame them. But to the extent that that happens, and to the extent it happens on a large scale, I think what you're going to see is a database that is bloated, that is less useful because of its bloat. And also, I think we should start like an internal pool at the firm as to when the database itself is going to crash. But that's something we can talk about offline.
Yeah, and you know, so to your example of 32.6 million companies, you know, over report, you know, put in more information than was actually required by the rule. Yeah, that's a lot of excess data that's not going to be useful or helpful to the government.
A lot of garbage.
And then, so lastly, in addition to the IRS, the website itself is not public. So it's maintained by the Department of Treasury, which also maintains all of our tax returns, for example. But there are some categories of people and entities that will have access. So federal agencies engaged in national security, intelligence, or law enforcement can access the database in furtherance of those missions. State, local, and Native American tribal law enforcement agencies can access the database and pull information from the database if so authorized by a relevant court. Similarly, foreign law enforcement agencies, if they make a request through like an MLAT, Mutual Legal Assistance Treaty, or some other mechanism from a federal agency in the US, will be given information off of the BOSS system in furtherance of those investigations by foreign authorities. And then what must have been an interesting compromise, financial institutions. So, for example, everyone on this call probably has a bank that they work with. They probably have bank accounts open at Chase or Citi or Wells Fargo. All of those entities have obligations under the Bank Secrecy Act and the Patriot Act to do know your customer identification. They'll collect passports and corporate documents, et cetera, to establish that the person opening the account is who they say they are. So the bank said, this is really interesting. We have this obligation to do KYC on our customers, to monitor their transactions, make suspicious activity reports when strange things happen. This database would really help us as a bank do a better job under the Patriot Act, so we should have access. And where the compromise appears to have landed in the rule is the financial institution will have access if granted access by their customer. So again, XYZ LLC, if XYZ LLC gives authorization to Chase, its banker, Chase would then be able to access the boss record for XYZ LLC. How I suspect this will play out in that example, I don't think Chase is going to mail a form and say, please check the box so we can see your boss records. I think there's going to be updated terms and conditions to your banking documents, buried somewhere in the fine print on page 7, saying by maintaining the account with Chase, you hereby consent to our access of the boss system. That's what I suspect will happen and how it will play out. And then off the back of a financial institution's access, the regulator of the financial institution would have access to boss records so long as that access was in furtherance of regulatory oversight of the bank. People have raised concerns about the security of the system. I think that's a valid concern. As we mentioned, there's going to be, photo IDs, proof of address, other potentially sensitive personal and commercial information being uploaded onto the website. Not to discount or otherwise be too flip. What I tell people is this information will probably be as secure as your tax return is, right? We know that hackers have attempted to access tax returns. I would assume that hackers will attempt to access this as well. One way the risk can be mitigated, however, is everyone can get what's called a FinCEN identifier. And so, for example, if I were to be named as a beneficial owner of 100 companies, instead of uploading my passport 100 times, I could upload it once, and I would be given a unique FinCEN identification number. And then on each of the boss reports, instead of my whole suite of information, I could just put in that information that would refer back to my identifier. That could be one way to mitigate the risk of data breach. But it's a valid concern, and I haven't seen that much from FinCEN on what their protocols are for data security. And that brings us to the end of our planned presentation. Happy to answer questions, happy to commiserate with anyone who thinks this is the worst thing ever. Happy to give you any guidance you might like, but use the time however would be best.
Hi, my name is Lydia. I have a question.
Sure.
Okay. You answered my question in the chat actually, but I just wanted to get a little bit more in the weeds on the subsidiary and the fund structure. So if the fund is an LLC, which means the technical GP is the managing member, and then the management company is the manager of the fund. The GP, the managing company is not mentioned in the GP entity, which is also an LLC. Is there control? I guess I'm trying to understand if the GP has any control, or is there any way that it is exempt in any way?
Sure. So is there a registered investment advisor involved anywhere in the structure? Or
that would be the management company. Well, no, it would be a VC exempt reporting.
Okay. That's okay. So something very odd and specific to funds. So the subsidiary exemption is not available for the pool. that would be listed in the ADV.
Okay.
There was commentary around that when the final rule came out at the end of last year. And FinCEN effectively said, we know what we're doing, and we deliberately made this choice to not allow subsidiaries of pooled investment vehicles to be exempt as such. Rather, each of these entities in the fund structure needs a different exemption. Now, what they did, and query if they did this intentionally or if this evidence is that they don't fully understand how fund structures work, is for both the registered investment advisor exemption and the VC-ERA exemption, those do have the subsidiary exemption available to them. So if you could show that, so for example, there might be an investment management agreement between the VC-ERA and the master fund, and then therefore the VC-ERA indirectly controls the master fund, which then in turn would mean it would indirectly control the entire fund structure. So that's advice we're giving to our fund clients and our VC clients, is if you can show through whether an investment management agreement, articles of association, or some other document that, you know, the top of the chain, and again, control is not defined, and it does not have to be wholly control. This has to be control of some kind that we can say, you know, in good faith that there's control. Anyway, if you can roll up to, like I said, either the registered investment advisor or the VC-ERA, looking at the structure in the fund documents, we're taking the position that those would then all in turn be exempt subsidiaries.
And Rob, I would add in that instance, though, the GP entities, if they don't have a contractual relationship for control with your exempt VC entity, your VC exempt entity, then you'd have to do a separate analysis for those GP entities.
Okay.
And then what's also somewhat annoying is the subsidiary exemption only goes down the chain. You can't go back up the chain. And so we have some clients, for example, where there's a registered investment advisor or VC-ERA. Great, that entity is exempt. But it might in turn be owned by LLCs or family trusts or a company. And so then that upper tier ownership entity, those would need their own exemptions, even though they own an exempt entity. So you can only go down the chart to speak with the subsidiary exemption. You can't go up the chain.
So just to be clear, control can be shown through a contract, like a service agreement. It doesn't have to be strictly by the corporate structure.
Right. So exactly. The rule says a subsidiary is anything that's controlled. Controlled is undefined or wholly owned. And then there was a lot of debate about whether it should be wholly controlled or wholly owned. And FinCEN said, no, we expressly did not put the word wholly in front of the word controlled. But we also didn't define the word control. So that in some ways that's helpful, right? Because it gives an opening to all of us to say, you know, this is control, or this is an indicia of control. And it doesn't have to be whole control. It's something less. And so, you know, the ability to, whatever it might be, appoint someone to the board, or the ability to sign contracts on behalf of the entity, right? Or I would think that would be control sufficient.
Right. So if we have one person who sits in all these different entities, we'll put a contract between the two entities, but we have that one person who kind of sits on the board here and there, that's helpful too, to also define control,
But that person,
even ownership.
Right. So the sole officer or sole director of all these entities is one of your employees, for example. I would say it's a control to me. But we're also telling people where this analysis is being deployed. And we benchmarked it with a number of other leading law firms in the fund space who are all coming to the same conclusion. I have a concern that FinCEN doesn't realize that they left the back door open, you know, through the RIAs and the VC-ERAs to exempt the whole fund structure, when they deliberately closed the front door and said you can't use subsidiary exemptions for things that are owned by the fund itself. And so I have a worry that, you know, at some point in time, and some of these law firms have actually put white papers on the internet. So at some point in time, someone at FinCEN is going to stumble upon one of these white papers or otherwise figure out that the industry is doing this. And if they didn't understand that that they created a loophole effectively, they might try to close it.
Right,
And
right.
so, we're continuing to watch, every time there's an updated set of FAQs, we scan them quickly. But also I just would like, our clients and friends to be able to identify entities quickly to which this analysis has been applied in case it changes in the future. You don't have to go back and review the whole corporate structure.
Okay. All right, great. Thank you so much. Thank you.
And then in terms of the reporting itself, there are a number of corporate secretarial services, so CT Corp, CSC, a number of others, that our understanding is they're going to offer to do the BOSS reporting for you. However, you will still need to figure out what needs to be on the report, but they will do the mechanical filing.
And I'll say for those of you who don't necessarily interface with the type of filing agents that Rob's talking about, you're probably all very familiar with cap management companies like Carta and Pulley. Those types of entities are all purportedly going to roll out some version of doing these filings for you. And the hope is that they'll be able to streamline the process a bit, but we'll see. Everyone is indicating that they'll have functionality starting on Jan 1, but we have sort of yet to see what any of that will look like or what the final details are. And so I think it's going to be a lot of collective holding of breath and seeing what comes in January.
So I guess the last thing, it's not too late to hope for a holiday miracle. So a bill actually passed the House of Representatives at the end of last week that would delay the implementation of the CTA by a year and would extend some of these 30-day reporting deadlines to 90 days. So it's with the Senate. So to the extent that you have your senator's phone number at your fingertips, give him or her a call. You'd be doing not just yourselves, but the 30-something million other companies that are going to have to make reports of a huge favor. We'll see. 13 days, it's not a lot of time for something to pass the Senate and get signed by the president, but it has in fact passed the House.
All right, well, we are at time. Thank you, Rob and Paula, and I know Melissa had to drop off a little early, but thank you to Melissa for the information. And for anyone else on the call still, if you have further questions or follow up, feel free to reach out to us. It's a new regime. Lots of people have questions, and so you are not alone there. But you've got our contact info, and don't hesitate to reach out. We're happy to help talk to you further about this.
And we will share the deck, after the call ends. A couple of people asked for it. We're happy to share it.
Wonderful. Thank you, everyone.